Welcome in, everyone. It is Thursday, September 23rd, 2021, and we're here coming to you live from St. Louis, Missouri at the Americans for Equal and Shared Parenting Legislative Summit here. I'm your host, Mark Reel, and today we have a very special guest. We have Missouri Attorney Jeff Millar. Jeff is the founder and managing member of Millar Law Firm. He's been practicing law for over 20 years in several states, barred in Missouri and Illinois. Not only is he a practicing attorney, though, he has been a driving force and an advocate for equal and shared parenting in the state of Missouri for the past 5 to 7 years. Missouri's been one of the most active states in terms of getting bills introduced. He's also a registered lobbyist. He's testified in 2018, 2019, 2021 on their equal and shared parenting bills. And he's also testified on other family law reform matters, including HB 1315, which aimed to reform the practices and procedures of guardians ad litem. So this is an individual who's been very active in the space for several years now, so excited to get an opportunity to chat with him. So Jeff, thank you so much for coming over. I know you weren't going to be over here until tomorrow for the conference, right, but you came over to make an appearance on the show, so thank you for that.
Well, it's a pleasure to be here. Thank you for having me.
Yeah, you're very welcome. It's our pleasure, really. So first question, I told you when we were going back and forth earlier today, in your bio you gave me, you and your son. How old's your son?
He's going to be 18 in 3 weeks. I can't believe it.
Oh, wow.
Yeah.
Okay,
yeah.
So you guys have been to 20 of the 30 Major League Baseball stadiums, and those of you that know me know that I used to say in my first life I worked in professional baseball. What are some of your favorite stadiums you've been to?
So we've actually been to 22. We did the 2 down in Texas this summer.
Okay.
So each summer we take about 5 or 6 different ballparks to go to. So we did Texas this year only because of COVID. We didn't want to hit the East Coast parks. Not sure if they canceled the game. I mean, we're stuck, out there. So some of my favorites, though, gotta be. My favorite is out in San Francisco.
Oh, that's
just with the bays, and that's one of my favorites. I really like PNC Park in Pittsburgh. Mm-hmm. The bridges going across are beautiful. Now, but the funny thing is, though, you ask my son. We've been to 22 parks, all out west California, down south, and out down Florida, and in the Midwest. And you ask my son what's his favorite ballpark. He says Kauffman Stadium. Kauffman Stadium in Kansas City. It's like 4 hours from here.
To be fair, I went to law school in Chicago, and I lived for the first 2 years of law school. I lived 4 blocks away from Wrigley.
Oh wow, great!
And the experience is unmatched. And I was in Chicago. I didn't live in Wrigleyville at the time when the Cubs won the World Series.
Oh, great!
Can't top that. Can't beat that experience.
Yeah.
But San Francisco, ballpark-wise, not atmosphere-wise,
right.
Miami's a beautiful ballpark.
Yep.
I haven't been. The ones I haven't been to are up in the Northeast.
Yes, that's what we're going to need to do next summer. Yeah.
Yeah. So we'll get back to what brought us here today, and as always, we start out with what's going on at the state level, and we start out with the National Parents Organization scorecard. So. Taking a look at that, the state of Missouri grades out as a C+, mm-hmm. which is average, maybe a tick above average in terms of where it sits compared to the other states. Now, there's been a lot of movement, and you're obviously someone who's been on the ground and been testifying. So mm-hmm. dating back all the way to 2016, there's been a ton of activity, but maybe not a ton of movement in the state of mm-hmm. Missouri. Do you kind of want to tell the viewers about what we've had going on?
Sure, yeah. So first, before I start, big shout out to NPO. Just some fantastic folks there, and they have done a lot of background work in getting surveys done that we'll be talking about this throughout the weekend, but that have been instrumental in getting the nation's best equal shared parenting law passed in Arkansas. They did some similar survey work for Missouri as well. So great job by our team there. Missouri started. This will be coming up. Will be our 8th year, and it started. So a few years before, I guess around 2014, 15, is when bills started to get filed. 2016 was a bit of a watershed year because that's the year we first got into statute terms regarding equal parenting. It didn't quite make it into where it needs to be in terms of what we call a rebuttable presumption, and that's what that is just sort of like a starting place. So if you think of a football game, instead of starting at in the end zone or at the anywhere like the 20-yard line or whatnot, why are we not starting at the 50-yard line? So that all began in Missouri in 2016. And what happened in 2016 is a change to the statute. It was 452.556.1. And basically it said that court clerks are required to create a handbook to help parents create a parenting plan. And in so doing, the language was they have to create guidelines as to what to include in a parenting plan. And here's the key: in order to maximize to the highest degree the amount of time the child may spend with each parent. Great sounding language. It's just not beefed up in the right place. Yeah, in the right part of the statute. And we need something that directs the judiciary to say, this isn't a clerk creating guidelines for a handbook. This is the judge saying, we're starting at 50-50. Now, some do. Some do. The problem is our counties are if you've got counties here in the St. Louis metro area, you've got a couple counties divided by the Missouri River. And the problem is you can start with a judge in one county who says we're starting at 50-50. You can go 20 minutes across the river and get the exact opposite experience. And that just shouldn't be the case because it's a state law. It needs to be applied consistently, regardless of the courtroom you're in, the judge you have, the lawyer you have. So that's why we need to give it, and we've been working since 2016 to say, well, now we've got the basics, the model. Now we've got to give it some teeth and say, here's where you start. And it ought to be that you shouldn't have to prove you're a good person. I mean, I hate to compare it to sort of criminal law, but in criminal law, we've often heard, you're innocent until proven guilty. You don't have to prove your innocence legally in criminal court. So why is it any different for a parent? Why does a parent have to come in and prove I'm a fit parent? I mean, the presumption, and there's some U.S. Supreme Court cases that say, a parent is presumed to be fit. Well, if that's the case, if you're presumed to be fit, then you shouldn't have to prove that. The burden should be on the other side, the parent who believes you're not fit, to prove you're not fit. And so that's what the intent of our work, our lobbying, our legislative drafts are to say, no judiciary, you start where they're both fit, they have equal time. If someone is offering why there should not be equal time, well, they've got to come forward and prove it. Otherwise, you shouldn't be spending tens of thousands of dollars and years of time to get that time with your child. I'm fond of saying, there's no point going to court to get more time with your 5-year-old if by the time you get it, they turn 18 in 3 weeks. Or they turn 8, or they turn 10. You're wasting time.
One of the things I always use, the viewers always hear me use, is when we're creating this change, and obviously there's a group of us here this weekend going to be working towards hopefully creating some change, but the first downs. Right now, we don't start on that 50-yard line.
That's right.
And in every single state, we have to continue to work and to get those first downs. And in a state like Missouri, there's been a ton of activity, but we saw, I think it was ended up being 6 states last year that passed some form of improvement.
Yeah.
And you kind of mentioned the 3 prongs we're looking for. We're looking for that rebuttable presumption. We're looking for the burden of proof to rebut that presumption, and then facts, findings, and conclusions if that presumption is rebutted, so there's some accountability.
Well, and that's the other part of the change in 2016 that happened, is part of that law said judges have to enter facts, findings, and conclusions of law for their judgments. So they can't just sort of willy-nilly say, well, I'm going this way, and da-da-da. No, they've got to have something substantive justifying their order. It also comes after, so that's the aspect of the law that happened in 2016. After that law went into effect in August of 2016, there's a very important case that came down in Missouri called Morgan v. Morgan. And Justice Page did a terrific job analyzing the custodial statutes in Missouri as well as this new law. And she said in her opinion, the intent of the legislature is clear. joint custody is favored. And look at this language about creating the handbook. It says to maximize the time with each parent. So what we're going to interpret that new law is saying is it ought to start at being equal. The problem is it's just, with so many different counties, so many different courts, it's just not been strong enough. And that's why we need to create a follow-up bill like all these other states are now doing. Yeah. And we've worked with, you know, half dozen, 8 or 9 different states like Arkansas, like Wisconsin, like Michigan. That's the great thing about volunteering for an organization like Americans for Equal Shared Parenting, even though I'm Canadian. Canadians are for it as well. Is we've been able to work with all these different groups, you know, like NPO, like the folks in Arkansas, to draft core quality legislation that's consistent. It's consistent from each state. So we're basically in the process of drafting and eventually adopting a uniform statute on equal parenting from the beginning. And it's just from the beginning. I get if there's other issues, that's fine. You got to come into court and you got to prove it. You can't just, you know, make allegations in a pleading. Because what often happens is, you know, gosh, in some of these counties, I practice in about 4 or 5 different counties here in Missouri, and they're all about 3 or 4 months away from your initial case management conference. Mm-hmm. So someone files their petition for custody or divorce, and you're looking minimum at 4 months before you get in front of the judge. And even then, that's just a case management. That's not nothing substantive. It might be another 2 months before you get there on an evidentiary hearing or an evidentiary motion, basically a motion for temporary custody. That's 6 months. If you haven't seen your kid in 6 months and that kid is 3, 4, 5 years old, or however the age, that is a huge problem. So what our attempts are in drafting this legislation is we also need to get a temporary order done within the first month. Mm-hmm. So here's the deal, and this is the standard. It's not. You can still vary it in terms of, even though it's 50-50, you can achieve that a number of different ways. You know, week on, week off, 2 days, 2 days, and then 3 days over the weekend. Every other day if they're a young kiddo. So it's not, you know, we're not forcing, you know, some default thing. You can still vary it. We're just saying the default presumption from the beginning is equality, and that's what this country was founded on.
Yeah, and I just, on Wednesday, I had a very frustrating initial hearing, and it was a father who the mother had just decided on her own to start withholding the child. Yeah. She withheld the child, she files, and then she relocates. Then she blames the distance as being the reason why there can't be something more equitable. Yeah. And you look at the judge and say, she's caused every bit of this. She's caused every bit of this. Yeah. It wasn't one of those cases. There were no substance abuse, there were no domestic violence, which unfortunately is in the minority. Mm-hmm. I think I exclusively represent fathers. Mm-hmm. And I would say the majority of the cases I get coming in, there's one of the kind of the holy trinity of allegations coming in. There was none of that. Yeah. And the judge ended up granting him in the initial hearing 16% custody. And he had the child. We did the math. Prior to the mom withholding, he had the child about 55% of the time.
Yeah. And that's why the fix to this issue is legislative, and why these groups are so important to drive the law through the legislature to then cascade down upon the judiciary that says, and, you know, it gives them, you know, an out or a hook to hang their hat on too. They can just say, hey, look, here's what the legislature's decided. They're the elected representatives. They've decided this. If you have a problem with the law, take it up with them, type of thing. But we're now starting from a point deemed by the legislature to be where we ought to start off.
Yeah, and then we see a lot. I think I'll admit I'm very new to this movement. It feels like in the past 18 months to 2 years that the snowball's gotten bigger. It's rolling downhill. It's becoming something that's more mainstream and more acceptable, and there's more conversation about it.
There is, and I think you're also seeing a change in the demographic. I mean, I represent both moms and dads, and I don't see it so much as a gender issue as I see it as sort of like almost a mental health issue, which courts just aren't equipped to deal with. But we're seeing a change in demographic. I mean, tomorrow I'll be celebrating, the 10th anniversary of my 38th birthday, or the 20th anniversary of my 28th birthday, one of the two. But, you know, we're sort of the last generation that, you know, has this ridiculous one night and every other weekend. A lot of my younger mom and dad clients, they're actually coming to me saying, we want to do 50-50. We just want to make sure, or I have this little concern, like, okay, well, here's how we deal with that. But yeah, it's nice to see the demographic switch, because I think these parents that are now in their, say, mid-20s or so, they may have grown up not seeing one parent, not seeing mom, not seeing dad. And they know it's ridiculous. They know that seeing one parent 15% of the time was not in their best interest. So they're now coming saying, I want to do 50-50.
Yeah, we had this exact same conversation last week. I had California Attorney David Millar on, and we were talking about when a 20 or 30-something-year-old comes into my office, they almost exclusively say, I want 50-50 custody, I want something equitable. And when we have situations where I'll have the older clients, they're more like, I think I have clients from 19 to 87.
Right,
And the older they are, the more likely they're just to say, like, hey, every other weekend's cool, where I represent several, I would say, in the demographic 18 to 24. And it's almost exclusively like, I want it to be 50-50. That's what it needs to be.
Yeah, and I think, and that gives some hope and some optimism to this. I think regardless of the legislative issues or change that, that's coming just because the demographic is changing. But that's the other key part of this is then the drive for the good quality legislation we've drafted and helped other states with is to make this consistent. So it doesn't matter what courtroom you're in or who your lawyer is. Here's what the law says. Yeah. And let's kind of, I don't know, let's do what the law says we should do.
Well, good idea. And here's the other thing too. Just in this case on Wednesday, I said the decision by the judge was extremely frustrating, because we go in and we make our initial arguments, and in California, like those initial hearings, they're kind of back and forth. The judge will say, go out in the hallway and meet. Sure.
We'll
go back and forth things. So we have this initial piece, and we put on kind of our initial quick 5-minute pitch of the situation and what needs to occur. And the judge looks at it and she's like, I don't see the reason why this can't be 50-50. And so we walk out in the hallway and we're like, oh, wow.
That's great. You got a good judge.
This is fantastic. Yeah. Like, we're going to be able to do something. And we go out in the hallway, and I'm going to name this attorney later. I'm not going to put this in the interview with you because it was wildly inappropriate. We start having conversations, and I'm like, okay, so they want 50-50. She's the one that reload, but he's willing to drive everything.
Right.
So, like, what are you thinking? Like, they both work full time. Do you want, like, is it a 2-2-5-5? Is it a 3-4-4-3? Week on, week off? The judge said they really didn't want that. So next time we go in, we're going to have to educate the judge a little bit on that piece. And the attorney's like, no, we're not going to agree to any of that. And like I said, in this case, the mom was the one withholding the child.
Yeah.
And the attorney starts yelling down the hallway that if he was a good dad, he would have filed quicker. And I had some not so kind words, and I'm quite a bit larger than him, and that quickly ended the negotiation. But there's some attorneys, and he was a little older, he's probably 55, 60 years old, that it was ingrained in him that it's like, no, like, mom gets to do whatever they want.
Yeah, the problem is, I mean, I'm kind of also fond of trying to cut through it a little bit. I mean, the problem is, unfortunately, you pay your filing fee, you have a right to be a jerk. Yeah. And I'm sort of getting to the point now where if I'm in that type of situation, then I just say, then set it for trial. We can't. I'm also fond of saying this isn't rocket science. I mean, it really is not rocket science. The studies, oh my gosh, over 100 studies have just come out and been clear that children benefit best from equal access to both parents. So we can't.
North of 125 now. Whether it's either maximizing time with each parent or relatively equal time.
Right. So what we can no longer have, and we've got to, again, with the new demographic and sort of passing a retirement, hopefully, of sort of the old guard, we cannot have situations where you do endless settlement conferences for 2 years while, you drain the parents' funds for attorneys, and after 2 years, well, we can't agree, let's set it for trial. No. I mean, this is why we need a temporary order within the first month when a case is filed. And if they're going to execute on their right to be a jerk and request a trial, well, then fine, let's try it within a year. I mean, there should be no reason this takes longer than a year, especially when you've got young kids that need the stability put back in their life.
Yeah. California, they say 18 months, but I'm not aware of any cases that actually go to trial. I mean, I know I have a hearing next week, and the case is 6 years old, and the trial's going to get set a full year out.
Yeah.
So I mean, it's 7 years of now high school age kids going back and forth. So I think a lot of that, I think that a lot of the studies now are coming back is when we get to that 50-50 point, it takes away the power dynamic.
Right.
There's no longer one parent in control. It's no longer...
Sure. And so I didn't mean to cut you off. Yeah, and like I was saying before with, how I see this more of a, a mental health issue, but in that regard, things like control, the emotion. I mean, this type of law is unlike sort of any other, perhaps maybe other than criminal law, where you're losing your freedom, although losing a child, that to me is, the equivalent of a civil death sentence. But, it can't be in a place where it's, taking this long to get to it. And having these laws do is they cut out that emotion. They cut out that desire to control. You're not going to blow $300,000 total, both sides, on attorney's fees, because that's both your kid's college education and then some. And it clearly comes down. And because I represent both moms and dads, I don't see it so much. Of course, men are statistically harmed more by the family court system, but moms are too. And so I don't see it so much as a gender issue as I see it as a mental health issue. And this 50-50 cuts that right out.
Well, I mean, the 50-50 does multiple things. I mean, all the studies show that actually moms there's actually the Women's Legal Center, I forget what the formal name of it is, Women's Legal Center, it's out of Georgetown University. Women who have between 75 and 50% custody of a child have better mental health scores than a woman who has 75 to 100%.
Well, and honestly, I was just reading today, where was it, on a few websites, 50-50 frees up moms to head back out into the workforce. And, again, with that changing demographic, that's what we want.
The Women's Law Center, the same place had the study that shows that women are 54% more likely to earn six figures in a 50-50 arrangement.
I did read that. Yeah.
Than they are.
Absolutely.
Than they are not. And then you look at, essentially what we've done is we put all the burden and we force dad to work. And I keep coming back to this situation I had this week in court that just didn't make any sense. Well, this dad looks at me and he's like, to be able to foot this child support bill now, I'm going to have to work during my parenting time on Saturday. Like, it's going to be my fiance caring for not our child, but for my child and other relationship. It snowballs.
Right.
We put so much parenting responsibility on the woman that it hinders their ability to create a better future, and then we saddle the man with so many obligations that he can't be the present parent that he needs to be.
Well, and what I also do with all my clients when I take in a new case is I discuss with them. I have my new division of labor conversation with them, and moms now has this extra time, 50%, to go out and work. You're gonna have to work. And guess what, dads? You're gonna have to figure out how to clean, cook, do laundry, and all those other parenting roles that are non-traditional. Now, again, the younger demographic's already there, you know. So, but you decided to divorce or separate, so there are consequences to that, and it just means now you've got to wear both hats. You've got to be, the provider and also the home economist as well.
Yeah, and then I see multiple cases where the woman comes in and says, well, he's always been the provider and I've been the one at home. Well, you're not together anymore.
That's right.
We're 2021. We've kind of gotten past. I mean, there still is in California at least, some of a situation where your role prior to the breakup plays into account. Yeah. My opinion is it shouldn't. You play roles in a relationship. If the relationship doesn't exist, those roles should go away.
That's right.
But you do definitely see that quite frequently. But I see a lot of that where moms come in where it'll be typically I would say probably 50 to 60% of my clients are unmarried couples.
Oh yeah.
And they'll come in and it's like they weren't together for that long, but mom stayed at home for a year, 2 years. Now I'm seeing some crazy things where like mom left the workforce intentionally when COVID with the unemployment benefits that you had, and now they're claiming, oh, I can't work, I don't work, and I'm like, you can walk into any business on any street in the state of California and probably get hired.
That's a hard argument to make now, and I've had that same conversation with my clients. It's like, there's a labor shortage. Yeah. So I don't want to hear you say you can't get a job. There's plenty of jobs out there.
I'm live in Corona, California, just outside of LA, and I live right off the main drag, and I don't think there's a single restaurant. There's a Walmart, there's another grocery store, there's about 15 restaurants. I think all of them have now hiring on the outside.
I agree. There's so much now. Yeah.
So this is actually a really good question that kind of plays into the legislative front. Oh, I hit the wrong one there. So I'm going to pare this down, and Jeff can't see it. Normally the guests can see it because it's up on their screen, but I'll read it here. So Mike asks, really at the core of his question is, he's reached out to his state senators. In Nebraska, it appears that the legal age that child support cuts off is 19, which usually it's 19 or high school graduation in most states. But the core of it is he's reached out to his state senators, and he has not been able to get in contact with. Being involved in that process, what tips would you give parents that are looking to help create that change in terms of reaching out to their local legislators?
One of the biggest things I've learned from a friend of mine is decisions get made by those who show up. You've got to show up. Go to your capital. You know, it's one thing it's really tough to cold call your representatives. They've got so much going on, and it's just a phone call. When you show up, they can't dodge. I mean, you're there in person. They can't, have someone say they're in a meeting and not take your phone call. So showing up is the biggest one. And actually, the response you get is actually you're very well received there, because your legislators realize, oh, you've made a trip to the Capitol. You may have driven a couple hours to get here, and do that, a few times. Start making a habit of. They're more than willing to just sit down and chat with you. And after you go a couple times, they start recognizing, who you are, and then you start doing. And this is the key thing for getting legislation passed, is then you start developing relationships. That's what you need. And the other tip for your I want to say caller. I'm not going to call
viewers.
For your viewers. Yes. The other tip for your viewer that asked that question is during the off session, you've got to get involved with their events. Go to their fundraisers, go to their activities, go to their pressers, because then they're going to be like, oh, wait a second, this is the guy I saw. I'm like, oh, now he's coming to my events, and then in doing that, you're also going to meet other people, and you're going to start to broaden your just your base of you broaden your contacts. You're going to meet that representatives or legislators, buddy they got elected with or something, and you're going to start to, and next thing you know, you've probably got about 4 or 5 or a half dozen legislators that you can tap into. So those are my tips for how to get in touch with and be effective with your legislators.
Yeah, and I'll kind of piggyback for those that watch every single week. Probably about 2 months ago, we had Brian Vandiver on, who's part of the group in Arkansas that got the phenomenal law passed. He'll be here I believe on Saturday. He's going to be coming up. But that was one of the points he harped on. It got to a point where the legislators knew who he was. He showed up at the state capitol in Little Rock, and he was walking office to office, and they knew why he was there. They knew who he was. They knew him by first name. Many of the staffers and different things knew who he was. So there was this relationship to where that phone call could eventually take place. Hey, we're going to take Brian's phone call. We'll hear him out, because he's going to show up if we don't take this phone call.
Exactly. And I kind of chuckle, but I've got to imagine on the other end when they see us show up. These guys again? These guys are going to keep showing up. Yeah, we are going to keep showing up. So you're going to need to listen to us and talk with us. And we've built these relationships over 7 going on 8 years now. So it's real key to start that process.
Yeah, and the other piece too is a story I've told before on here too is my co-author of my book that's going to be released this fall, Andy Tyler. He's going to be here with us in St. Louis here probably in a couple hours. But he tells a story of, he's from the state of Indiana where I was born and raised, and he just on a whim called his local representative, and they literally got to him the same exact day and had a 90-minute conversation. So every legislator is not the same, and I think people don't realize how accessible and how we'll call them normal people. Our
Yeah.
state senators and our state representatives are. They're business people, they're lawyers,
Oh, yeah.
they're former police officers. I mean, these are normal people in the community. It's not someone who's been in the political machine typically
Right.
for 30. You do have those at the state level, but in general, it's not someone who's so detached from their community that they're not able and willing to have conversations with the people, because they want to know what the pulse of the community is.
Especially if you're their constituent. They
Yeah.
like to see you in the Capitol. Yeah.
Yeah, that's definitely. So we'll kind of transition here, and I know it was one of the. Let me pull up here and get the bill number. So in 2021, you testified on the guardian ad litem reform 1315. So one of my biggest issues with the current family court system is I say it's pay to play. At the end of the day, it's pay to play, whether it be you get slapped with unreasonable supervised visitation, you got to foot that bill, evaluations, therapists, court costs. Some judges are having you return every 3 or 4 weeks to court, and
Time off work.
yeah, time off of work, and then you're paying several $100s an hour for one of us to be there to represent you. So in terms of what's your opinion on, we'll go specifically with guardian ad litem. It's not super common in the areas I practice to have a guardian ad litem or a child's attorney. But what's your opinion on them, and what type of change do you think would make those individuals more effective?
So a guardian ad litem is supposed to be an independent lawyer that is appointed by the court to help advise the court as to what it ought to do in the best interest of the child, independent from the zealous representation that mom's lawyer and dad's lawyer give. So that's guardian ad litem, and they they provide a very valuable role. They're needed. As attorneys, we take an oath to zealously represent our clients, not necessarily the child, and that's where the guardian ad litem comes in. Now, with everything, there are bad apples, and I think the biggest focus.
We've seen that in Missouri.
Yeah. I think the biggest focus for change needs to be on accountability. I have had months go by trying to get in touch with the GAL. And you can call, you can email, you can, if I have to, put a letter on my formal letterhead and send it out, things have gotten pretty bad. And the reality is, the guardian ad litem sort of becomes someone that you've kind of also have to persuade or win over. And so it's difficult then to, I don't want to use the word challenge, it's too strong a word, but to seek some type of accountability that says, hey, I've been calling you for a couple of weeks and I haven't heard back. So I think the biggest change, or what we're looking or wanting to see, is some sort of accountability mechanism for them, because they provide such a valuable role to the court.
Yeah. And this is the thing. I think my piece, specifically how a lot of these third parties are used in the state of California, we operate under the presumption that a lot of times that dad has to prove he's a fit parent. And in reality, we need to take a look at it, and 99.999% of parents ultimately just want to spend time with their kids and want what's best for their kids. I think if we shifted our thinking to, okay, if there's an actual issue, if there's actual substance abuse, if there's actual domestic violence that we can ascertain from what's been provided, then these professionals may be necessary, they may be needed. But I think a lot of times we pull these professionals in and it just muddies the water. And in my opinion, I think a lot of judges, at least in Southern California, utilize these professionals so they aren't the ones making the ultimate decision. They utilize that opinion or that report, whatever they provide, to guide them in their decision making, so the ultimate decision is not on the judge.
I mean, we have our statutes here in Missouri are pretty strict in terms of, if there are allegations of abuse or neglect, a guardian ad litem shall be appointed. I mean, there's no discretion by the judge. They have to do it. So I think the fix there again is legislative. And that's why we've, at AFESP, we've worked so hard creating these relationships, and TFRM does a great job on outreach, and NPO with their surveys and whatnot. But the fix, the solution to these problems is legislative. And so if It is. And I think it should be. I mean, if there's no one wants a kid going to where they're going to be abused. So if there's abuse or neglect alleged, then absolutely a GAL ought to be appointed. But let's look at what it means to allege abuse and neglect. That's where the legislative fix comes in, because the statute in Missouri is so loose on what is required for an allegation of abuse or neglect. For example, it just says if abuse or neglect is alleged. It doesn't say by whom. I've had lawyers allege it, but they're not the parents. It doesn't say under oath, and it also doesn't say with any type of specificity. So, I had a case once where a lawyer came in and hand wrote, I'm not even going to say a one-line motion, a 5-word motion for GAL, dad abused kid. And the judge's hands are tied. I mean, the statute says if it's alleged, you've got to appoint a GAL. So I think, in addition to the accountability we just spoke of, I think we need to look at the underlying statutes and laws and fix those. Because I think if we had some guideposts on abuse and neglect, then at least I can say to my client, well, look, it's not a 5-word motion. Here's what they're alleging with specificity, so that I can then, investigate it, challenge it, look into it. I'm just not dealing with some amorphous, well, there's abuse.
Yeah, and I think that's another very, very large challenge. Are these allegations where I think there are a lot of states that have statutes, California is one of them, where abuse or domestic violence is defined so broadly that it's next to impossible to defend against these things that could be completely baseless. They could be based on something. You can't really pinpoint what exactly they're trying to say, but all of a sudden there are all these levers that have to get pulled because there's a domestic violence allegation, there's a child abuse allegation, and the party that it's being alleged against, the allegations are so vague, you can't even defend them to the judge. As an attorney, even it feels like this. You're basically saying, "Nuh-uh, that didn't happen," and that's all you can do.
Yeah. I mean, now it's a little bit different with, again, we talked about the younger demographic. Along with that younger demographic comes technology. So everyone's walking around now with a video camera in their pocket. And so, if that's always running, you might be able to, negate some of those. I mean, the problem is, domestic violence, is real. It occurs. These abuse statutes, because of that, are necessary. The problem is, on the other hand, as a practical matter, the Adult Abuse Act is one of the most abused statutes in Missouri. So, there's not even a filing fee, for crying out loud. Even $20. And again, that's another legislative fix we're looking at. If there were some type of filing fee, right now, it acts as without a filing fee, and the clerks are required to help a litigant write out the petition for an order of protection. It becomes, I kind of call it jailhouse justice. I mean, I'll show you, I'll get back at you. And I see it on both sides. Both men and women, file these things. The problem is I think legislatively need to find the balance between, because I've also represented, horrible cases of domestic violence where, mom just, had the pulp beat out of her. So we need the protection. It's real. It occurs. We also, though, need some, protections in terms of, a $20 filing fee waived if you accompany it with a police report, I think solves some of those problems.
Yeah, I think I won't even say one of the most abused in the state of California is Family Code Section 3044. And there are parties that instead of responding to a divorce or responding to a petition for parent, they filed file for a domestic violence restraining order.
Yeah.
And no joke, I had a temporary restraining order that got granted against my client after we had filed for custody.
Yeah.
Her allegation was that he drove by her house. They'd been co-parenting separate for 10 years. Her allegation was he drove by her house. And if we'd have been able to respond to that before they granted it, we had work records that showed that he wasn't even in the state when she made this allegation. But he all of a sudden loses almost a month worth of time of parenting his children. He couldn't go to his son's football games. So it's one of those things in California, the way the statute's written, it's used as a sword. It's not.
Yeah. So, and that's where a temporary order entered at the beginning of the case solves these problems, because it reels in the emotion. The first thing I'll say to a client who's filed an order of protection is I'll say, well, the first thing we're going to do is we're going to dismiss that. And their jaw, kind of drops. And I said, well, in Missouri anyways, it's only good for a year It can be extended for another year, up to 2 years. But if your kiddo is only 3 or 4, you don't need an order of protection. You need a parenting plan. You need a custody order. The problem is orders of protection have no filing fee, and you have assistants filling it out. You don't have to hire a lawyer for it. That's why it's the go-to thing to do.
And in the state of California, it's what's preponderance of the evidence to get
Right.
the administrative restraining order granted.
Right.
And in the state of California, that creates a presumption for 5 years that parent that it's granted against shouldn't have any legal or physical custody. So all of a sudden, I mean, I would say 70 to 80% of my clients have either, prior to me representing them, had a DVRO granted against them, or we've defended against a domestic violence restraining order. But it's such a sword that, I mean, like I said, the client who he had to, like, we had to go in and defend that he drove by.
Right.
It was a hearing that we were in front of the judge for 5 minutes, and the judge was like, no, this isn't anything. In my head, I'm like, why did you sign off on a temporary restraining order being granted? Because your name's the one that signed off on this.
Right.
But that dad, all of a sudden, that was the preparation, and multiple witnesses showed up that day, everything else. I mean, everybody involved, like, lost work, attorney's fees, filings, everything. It was probably a $2,000 expense to their immediate circle to disprove this flimsy allegation that was just signed off on without looking at it.
Well, not just that. I mean, can you imagine? I know a lot of your viewers don't need to imagine. I'm sure they've experienced it. But coming home from work one day to a sheriff standing there saying, you've got 10 minutes to get your stuff. It's, well, where am I going to go? Sheriff's, it's not my problem. And where are you going to go? A buddy's couch? Your parents' home? But what about the job that you've got to have your work attire for, or whatever, or your tools? You don't have time to get all the tools in your shop, in the garage or something, but again, I think what we work towards with AFESP is a legislative fix to these. So I think some ideas like a filing fee, you waive it if there's a police report, will help hopefully curb some of the abuse. It's
a very tricky issue, and this is, and I've never had, obviously 3044 in California is something that needs to be changed because of how it's weaponized and how it creates this contention when it's really in most cases not actually necessary. It is necessary in some cases.
Well, if you can get in early enough, and that's, the best work I can do is when I can get into a case early enough. When someone comes to me saying, well, I want to file an order of protection, I say, wait a second, let me what's going on? Well, he drove by my house. Well, that's not quite enough. What you really need is just, let's file your divorce or your custody and deal with it that way. So if you can get in early enough, because what that does is that controls the emotion, that controls that I want to get back at him or her. The way you get back is, living your best life.
And I think that goes part onto our profession. I mean, there are several, like I know in the equal and shared parenting community, there are a lot of individuals who don't necessarily like lawyers. And I see that every week in the comments. But I would say the vast majority of lawyers, when the lawyers go to talk and it's just the two of them, are like, we really don't need these things. Our clients are kind of driving this. Like, is there middle ground that we can make a deal right now? Because I'll tell you this, like, the happiest that two lawyers, that at least personally in my experience, is like you show up to court on that first day and the two lawyers tell the parties go stand down at the other ends of the hallway, you meet in the middle, and before you even go in front of the judge, like, you're like, hey, we got this figured out. And it may be 2 months from filing to them having some sort of stability in terms of a custody.
Well, that's just it, is how do I get stability back in my client's life as soon as possible? And that means a schedule, their kids, financial things straightened around. And that's why, again, these legislative fixes are so important, because they do that. Again, there's no point going back to court to get more time with your 5-year-old if by the time you get it, they're 8. Absent, there are complex cases, absolutely. But, I mean, the majority of cases, it's not rocket science. There's no reason cases should take 18 months minimum. I've seen cases drag out 2-3 years. There's no reason. There's none.
Oh, I've seen it more than 2 or 3 years in California, definitely. So there's a couple people in here asking if we are taking questions. We are taking questions. We're going to take 3 or 4 here in the next couple of minutes. So drop your questions in the comments, whether you're on YouTube or on Facebook. So I want to ask you a question, because I know you have a background and you've done some class action work.
Oh, sure, yeah.
So one of and I guess this is a little bit of a tease, but of an announcement that's going to happen this weekend. But and that's as far as I can go. I promise it'll come out this weekend. But there's always a lot of talk, and I don't know how active. I kind of got my start. I was trained as a labor and employment attorney.
Okay.
I kind of got my start in it in going through my own situation, and then being involved in the Facebook groups and answering questions and things like that. And I'm not in there as much as I would like to be, or as much as I once was. But one of the things that would always come up was, is there grounds for, in legal terms, is to certify a class? Mm-hmm. And I haven't been involved too much in class action work. There's a little bit of it that happens in labor and employment, but it was mostly on the defending side, management side, labor and employment. Do you think there's potentially grounds for, whether it be state by state or nationally, for a class to be certified for just different things that occur within the family court system?
Well, I'll give you a perfect lawyer answer. It depends. Maybe. It's a definite maybe.
Our favorite answer. It depends.
It's a definite maybe. So, I mean, it's been, 10 years since I've done class work. But I mean, the biggest issue you'd have in, any type of class application of, family law stuff, or something that's called individual issues. So a class action, you've got to show basically uniform treatment. Although you read some comments and threads, and someone tells you their case, like, oh my gosh, that's my case. Or, there is a lot of commonality to it. But at the end of the day, you've got to show to certify a class or to sustain a class action. You've got to show uniform treatment or a commonality of issues. And I think with family law, just off the cuff, in the abstract, I think you're going to find there's too many individualized issues to sustain a class. Now,
here's a question. And this is the piece that I point out. I have that same thought. It would be very challenging to certify a class, even state by state. Mm-hmm. But
you'd have to do it state by state.
Yeah. So the state by state, and different states, certain states would be more ripe for the issue. Mm-hmm. So, for example, one state that I'm aware of that, or we'll just use the one that's had the most movement. It wouldn't be the best one because there's a lot of change occurring in the state law. But the state of Texas, where where it stipulates to, there's essentially the custodial parent and the non-custodial parent, and it's specific on the amount of time. I think it would have to be a state like that. Minnesota has something similar, where basically both parents start with 25%, and then the other 50% is up for grabs. I think it would have to be a state that has laws like that specifically lays out percentages. I mean,
yeah, you'd have to show a uniform application of that law. So, I mean, if each start with 25% and you've got 50, that gray area of the 50 is where those individualized issues comes in. I mean, if you could show in Texas under that code that, every single, judge in every single county always gives parent A only 10% and parent B 40% of that 50%, then it's a maybe. Mm-hmm. But I think that's the problem, is you're dealing with too much gray area. I'll see if I can think of a statute that might apply uniformly, but once you get into the weeds on it, you find it starts getting too individualized.
That's kind of my opinion. It'd be very, very murky, considering, and you mentioned this earlier, and this is despite the fact that this is an issue that disproportionately impacts men, at the end of the day, there's still 14% of women that are non-custodial parents, and I can guarantee, I know for a fact, not all of them are drug dealers or domestic violence. There are moms who also get the raw deal in this. Yeah. So it couldn't necessarily be gender-based, because I think that 14% is far too great to say this happens to men.
Yeah, and I think even challenges, I was just looking at this over the last weekend, I think even challenges based on equal protection of laws have also failed as well. So, I mean, I've read cases where divorced, I'll just use fathers, but divorced fathers are treated differently than unmarried fathers in application of whatever law, and challenges based on, I like the argument, but it's been an unsuccessful one, have been, well, wait a second, you're treating me differently based on the sole reason that I'm divorced versus as if I never got married. And courts have not been too welcoming to that argument.
Yeah, that would be in as much as I would love to say it would be something that could create a quick fix. I don't personally see it right away. I know there's a lot of conversation around that, and there are other issues too. If you go to federal court, so you try to certify in federal court, there are, like, the domestic relations exception is defined very, very broadly. Like,
sure.
Anything involving divorce and child custody is essentially immediately going to get kicked out under that.
I think so. I don't know how you'd get to federal court, and then anything under any class actions aren't quick. My last class action lasted 7 years.
I vividly, it was towards the end of law school, interviewed with a firm who exclusively did class action stuff. Very successful. They're probably the most prominent class action firm.
Okay.
All they do is class action in the city of Chicago.
Okay.
And the partners went, it was like 4.5 years where they didn't make a single penny.
Oh yeah, that's another problem in the profession. Yeah, and I'll never forget when the last class case I handled, resolved, and my son was 13. But I look back, I was like, my gosh, when I filed this case, my son was 6. So it takes a long time.
Yeah, definitely. All right, so I'm gonna look through here. Sorry, I'm looking away from the camera. My computer's off the screen here. I'm gonna find a couple of questions. If you have a question, drop it in the box. All right, question.
While you're looking, while I remember, let me just take this opportunity to say, go Cardinals! 12 in a row.
Hey, I saw they came back for the win. Grand slam in the first inning and then come back to win.
Not gonna lie, I mean, from Canada, I'm a hockey fan, but I turned it off in the 6th inning, and I taught my kid, real fans don't leave early, real fans don't turn off and I saw the tweets later, that's 12 in a row. I was like, no, it's not 12 in a row. They lost today. Sure enough, they came back from a 5-1 deficit, and man, oh man, I wish I had kept the TV on.
All right, so I'm gonna pull this question up, and I'm kind of gonna paraphrase the question. So Jeff Michael, essentially he's asking about judges. So question is it wise to report a commissioner or judge that told your attorney, regardless of evidence or videos submitted, it won't change his judgment? So I'm going to kind of shift the question a little bit. So how, and we'll direct this at really pro se litigants, pro per litigants, but if you have a judge that is, when you're representing a client that you don't feel is really taking into account the evidence, isn't really looking at the facts, how can you combat that? And I'll go first on this, because the first thing that pops into my head is that in California, just with how busy the court calendars are, you absolutely have to file briefs, you have to file declarations beforehand, and you have to build a theme. You're going to be in front of that judge once every 3 to 4 months, most likely, 2 to 3 times a year. There's no way this judge is going to understand your situation. For the past 18 months, we were virtual. They may not have seen your face. They've just maybe heard your voice. So it's building, it's having your themes and sticking with them. And then also, before every hearing, there's no harm in the state of California. You can file a declaration to give the judge an update. And so you can provide the judge with all this information prior to going in. The biggest mistake I see when I'm sitting in court and I hear pro per litigants presenting their cases, they haven't given the judge any information or evidence prior to the hearing. And these judges, they're going to read these documents. They're going to look at things beforehand, then they're going to kind of have an idea of what's going on. So if the other side's submitting things, you're submitting nothing. They're getting a one-sided story, and then you get your 15 minutes to present your side.
Yeah, I mean, the other big problem too is, and I get the realities and practicalities of financial constraints, absolutely. But part of the problem in representing yourself is just the emotion involved. So I think number one tip or pointer would be do the best you can to try and divorce yourself, no pun intended, from the emotion. Because otherwise you're acting on emotion, you're not coming out clear, you're not being succinct. The other thing to keep in mind is, I want to circle back to, if you think they're not counting on the evidence or whatnot. But the other thing, at these, you also have to know what the purpose of your hearing is. I mean, typically the first time out you have, a case management conference, which is just to manage deadlines and dates and things. Yeah. That's not your opportunity to, argue for temporary custody. You got to file a certain motion for that. And at those case management conferences or settlement conferences, they're not what's called evidentiary, which means you're not taking evidence. You're just giving the judge your sort of side of the story, and you don't have long to do it. I aim for about an estimation. I probably got about 30 seconds with this judge. So I got to get my best stuff out in 30 seconds. And it's hard because, I've created I'll have clients come to me with a stack. Here's all the emails and the texts they've sent. And I say, pick your best three. Try and picture, the court's heard this, however long the judge has been a judge for. They've heard the same story over and over again. And you've got to, so because of that, you've got to be succinct. They're not going to want to listen to you for half an hour. I mean, they're not going to listen to you for half an hour.
Here's what I do to my clients. On my desk, I have a copy of California Family Code, and it's probably about 2 inches thick.
Yeah.
And when they get in their feelings, I'm like, your feelings don't matter.
Yeah.
All that matters is what it says in this book of this code.
Yeah, and that's the problem with going pro se. You might not necessarily know that or know what your remedies are. I mean, if you don't think a judge has, listened to the evidence or seen it fairly, you need to know what are some of your procedural remedies. A lot of this, I mean, even with attorneys, I mean, the practicalities of it are who can, afford not just to go to trial, but also an appeal behind that. I mean, that's why, again, these legislative fixes are so important, because we need to cut through this, minimum $25,000, $30,000 trial expense, never mind the appeal, and figure out how to problem solve, how to realize I'm not going to get justice here. This is not about getting justice. If you're going to family court looking for justice, you're not going to find it. I've got to figure out a way of minimizing my exposure, my mental health, my finances to something that at the end of the day, I'm not going to be satisfied with, because you're not. So how do I make the best of it and get myself in and out in, say, 6 months or less? I'm not going to get everything. In fact, one of the first things I do to tell my clients is reel them back. You're not going to get everything under the sun. Mm-hmm. So I think, to try and answer the question of what to do if a judge doesn't analyze the evidence, other than, knowing your procedural remedies, the code of procedure, I mean, you need to know all that. That's why having an attorney is so important. Barring that, I think then you need to say, I've got to assume I'm not going to be satisfied with this process. So how do I maximize what I can, when I can, to get the heck out of here?
What are the 2 or 3 things that really matter at the end of the day?
Time with your kid.
Yeah. Well, that's when people go in there and I've had instances where game systems or different things.
Gosh. No.
I had a client message me about the PlayStation 5 the couple had.
Yeah.
And I said, I will fire you as a client if you ask me to litigate over
yes.
PlayStation 5.
Yeah. So here's what I tell mine. I say, it's funny watching it's not funny, I shouldn't say that, but it's curious when I give this advice and the jaw drops. And the advice is, give them everything. Yes, give them everything. We're not gonna fight over the TV. Why? Because you're gonna get a better TV. You're gonna get a newer TV. It's not gonna
matter in 6 months. We're not even going to address it.
I don't do that, because you can. That's stuff. You can always replace stuff. You can't replace time. So that's why, getting back to what I was saying in terms of, you got to maximize what is it I need to get out of it. It's not the TV. It's not the PS5. It's time with your kids. So how do I, worry about that, not the other stuff, and not who's picking up or taking to, how much time am I spending in the car. Heck, that's just more time with your kid. Offer to do all the transportation. You get more time with your kid.
Yeah, so. Definitely. Well, we're coming to a close to our hour tonight. Jeff, I want to thank you for making some time tonight to come over. It's been a little bit different. It's been our first live show. I know this week. This weekend you're probably gonna see more. I got Casey's right behind the camera. Probably gonna see more from the Father's Rights Movement this weekend, going live from St. Louis. I believe, you may know more than I do, I did have a link to the conference this weekend. I believe you can still purchase a virtual ticket to be able to get in on most of the sessions.
Yeah, if you go to the Americans for Equal Shared Parenting website, it's afesp.com. There should be a link there to how to go about getting those tickets.
Awesome. And then what I want to leave them with is, you're an attorney here in the St. Louis area. How can they get a hold of you?
Oh, appreciate it. Thank you. Yeah, go to, it's real easy, flatrate.legal is my website.
So flatrate.legal. If you're in the St. Louis area and you're in the market for an attorney to represent you, Jeff could be your guy. And I have, let me find it. I got one more. I think a comment that.
Real quick before hitting the comment while you're looking at it, I think I should say, I might be obligated to say with respect to that. The choice of a lawyer is an important decision, and it should not be based solely on advertisements, to the extent that's considered an advertisement.
Go with your gut. That's what I always tell everyone. Anyone who's in my office, that you don't have to pick me. I'm not the right person for everyone. You need to go with whoever you are most comfortable with.
I shared the link to get the tickets.
Okay.
Oh,
so we got the link in the comment section on Facebook. Casey shared that. So you can go and you can click that link and get a ticket to be able to watch most of the sessions. I don't think it's all of them, but the majority of the sessions this weekend. So I want to leave us with a comment. So Jason Newell, Jeff Millar is the shit. Jeff, I want to thank you so much. Thank all the viewers for watching. Next Thursday, we will be back. We're going to have Philadelphia, Pennsylvania attorney Larry DeMarco on. Once again, Jeff, thank you for making some time tonight.
Thank you for having me. Appreciate it. Pleasure to be here.
We will see everyone next week.